You're on 94.1 FM, 3WBC, with Jerry Guirguis presenting...
Downtown, everything's waiting for you. Downtown.
And now here's Jerry Guirguis, 94.1 FM, 3WBC, the voice of the Inner East.
Hang around and let your problems surround you. There are movie shows downtown. Maybe you know some little places to go to where they never close. Downtown, just listen to the rhythm of a gentle bossa nova. You'll be dancing with them too before the night is over. Happy again. The lights so much brighter there. You can forget all your troubles, forget all your cares. So go downtown, where all the lights are bright. Downtown, waiting for you tonight. Downtown, you're gonna be alright now. Downtown, downtown.
I'm Jerry Guirguis interviewing Paul Dellios, Principal and Founding Partner at Dellios West Co. here on 94.1 FM 3WBC Downtown, and it is pre-recorded on Thursday, the 27th of July 2023. Hi, Paul, and welcome.
Good evening, Jerry, and good evening to your listeners.
Thank you so much again for giving us your valuable time and informative opinion on this subject. We want to talk about practice directions in Victorian Law Courts. If I can start, Paul, by asking you what electronic devices are allowed in Victorian courts, such as we're talking about mobile phones, laptops, and cameras.
Okay. Well, according to the guidelines that are published by the Supreme Court, which effectively are replicated by all the other courts, the list is personal iPads, tablets, laptop computers, digital assistants, mobile phones capable of transmitting emails for electronic note-taking, messaging by text, and filing stories is what is allowed.
Right. Okay.
But not for everyone.
Okay. All right. So let's just now say the second part is I just want some clarification. So this is a true or false question, Paul. Accredited, sorry.
Go on.
Yeah. So this is just I'm going to ask you a question whether it's a true or false. Accredited media journalists, and we're talking about the media journalists who are accredited by various courts. Are they granted permission to make use of electronic devices for accuracy in courts? True or false?
True.
It is true.
And
right. Okay.
it is true. Now, the basic starting point is something that is described most concisely in the Magistrate's Court version of the rules, and that might be because it's the most recent version. So the Magistrate's Court version was revised in January 2020, and under the heading Statement of Policy, it says, upon entering a courtroom, you must not use your mobile phone to make or receive phone calls, take photographs, or make audio or video recordings of court proceedings without permission of the presiding magistrate, nor use any electronic devices where such use constitutes instantaneous publication, for example, social media platforms, including Twitter and Facebook and live blogging sites. And then it goes on to say the use of laptops and tablet computers is allowed for court legal and media business. However, these devices cannot be used if the device causes any disruption to the court. So that's the basic policy. Now, the courts have their guidelines about accreditation of journalists.
Yep.
So what is required, and the guidelines aren't exactly the same in relation to each court, but basically what's required is that someone who is going to be regularly appearing in the court, and this is the main criteria, that it should be someone who's regularly doing this. I think the theory that is that they need to be inducted and get some training as to court etiquette. But a regular journalist can present their credentials and be accredited in advance. And exactly how that works, again, varies from court to court and varies based on, the variation includes the difference of what they have to present. But for our purposes, let's say that someone who is employed, whether for remuneration or as a volunteer, probably doesn't make any difference. But someone who's employed and gets a letter of representation from a responsible person of a radio station, a station that has an Australian broadcasting licence, whether it's a commercial licence or a community licence, they, I don't believe, would have any trouble at all in qualifying for accreditation. So accredited journalists can use all those devices that I listed before to record proceedings, even though it's against the general rules to record proceedings. Then other people who are either journalists who don't have an accreditation, freelance writers, citizen journalists, or just members of the public, if they want to record or otherwise use electronic devices, they must actually obtain permission from the presiding judge.
Okay.
And then it's in the discretion of each judge how they deal with that and whether they believe that it's worthy or not.
On several occasions when permission was granted, but the presiding judicial officer says, no, you just have to zip it and sit down and say, yes, Your Honour, and do nothing. And then you can have a chat afterwards.
Well, I'm not sure how well you'll go with having a chat afterwards, but the overriding rule is that regardless of the general rule is that as far as the conduct of any particular proceeding or any aspect of any particular proceeding is concerned, that's entirely within the discretion of the presiding judge. Now, if the presiding judge makes rulings that, let's say, contradict the guidelines, then it's a matter of somebody lodging a complaint to the chief of the court. If it's the Supreme Court, the Chief Justice. If it's the county court, the Chief Judge. If it's Magistrate's Court, the Chief Magistrate. If it's the Children's Court, the Chief Magistrate and the Children's Court. If it's the Coroner's Court, the Coroner, in order to ensure that on future occasions a judge doesn't, let's say, do things in a manner that is contradictory to the provisions in the guidelines, because ultimately it's in the court's interest for the court's proceedings to be reported as fairly and accurately as possible. And on the emphasis of accurately, of course, there's no more accurate method than enabling what is actually done and said to be recorded electronically. Then it's a question of, next step is the question of how the journalist actually uses that, because even though they can make those recordings, then they've still got a duty to use them in accordance with other provisions of these published guidelines. They can't just then decide that they're going to sell it on the internet, for example.
Yes, I do understand that. The additional subject to all of this, Mr. Dellios, of course, is the stenographers, and they've been around for a very, very long time. They sit there quietly with a little miniature typewriter. It looks awkward, and I'm sure they can type something like about 300 words to a minute. And I sort of looked up some of the stenographers in the US, and there's big competition as to how accurate these people, an accreditation process and education that's done. We've got stenographers in all proceedings, and again, accredited goes to all the stenographers. They for the capacity to be able to type every word, everything that was said is amazing. So, yes.
Well, it is, but you'll be probably sad to hear that most of them have become redundant because they are, in fact, replaced with technology. And, in fact, it's a combination of technology to actually record and the technology that, in fact, transcribes the recorded voice to print.
Yep.
And then there are people whose job it is to edit those and check those to make sure that they haven't incurred too many errors in the electronic transcription. Optical character recognition in reverse. So this is voice to print. And
yes.
So that is what is predominantly used. And I'm just trying to remember the last time I saw an actual stenographer there. And of course, you must realise that there was a trick to what they did.
Yes.
The reason that they had little typewriters is because what they were actually typing was in shorthand.
Yep.
They weren't typing the full text as you and I would if we were able to type.
Yes. The other thing is that's coming, and we've had the chance, Paul, to speak about audio-visual link. And in the times when we had COVID, and there was a lot of cases were actually done for the purpose for time and convenient, and AVL, audio-visual link, was implemented and rolled out and used quite a bit. And I suppose that's another additional electronic means of, staying with what is really happening in reality in the courts. So any experience with that? Can you recall some of the pros and cons of the audio-visual?
Well, it's used in two contexts. One context is where it's necessary to take evidence from someone who can't attend court. And in that case, it's a real benefit from the perspective of, instead of the old-fashioned approach of somebody having to go, meaning the court, and a judge and the lawyers and other people having to go to a hospital to take evidence from someone in a hospital bed, or having to organise a commission of evidence, which is taking their evidence in document ahead of the actual court hearing. That can now be done more readily just by taking the video equipment, if the facility where the person is doesn't already have their own video equipment, and the video equipment can be as little as an iPad or even an iPhone these days. So last year I was involved in a coroner's court inquiry about a murder that had taken place 40 years earlier. And it was during the COVID lockdown period. So the coroner's hearing, which lasted for 17 days, was conducted partially by people being allowed to be present in court, but because of the lockdown, there were limitations on that, and other people were forced to participate remotely. So we had a situation, if I just talk about myself and my client, we had a situation where I'm sitting in my office in Fairfield. I've got a barrister representing my client who happens to live in a country location. So he's sitting in his study at home in a country town. And we've got the client and his family sitting in a house in the northern suburbs. And he was a very, very major witness in this inquest. The trouble was that so was his wife a witness for the same inquest. So the situation was that the coroner's sitting in court. There are the counsel assisting the coroners, and there were 2 or 3 different barristers who were assisting the coroner, and the victim's family were in court, and occasionally other lawyers were, I think, lawyers representing the Director of Public Prosecutions and different lawyers representing the Police Association were allowed to attend court, but that was about it. Other witnesses had to be examined remotely, and legal representatives who were appearing on behalf of any of the witnesses again had to deal with this remotely. And that created some difficulties. There were some occasional technological problems, but one particular issue that arose was this. My client needed a young member of his family with him because he couldn't operate the technology on his own. So that was fine, and there was no problem with that. And he gave his evidence, and it took quite a while, but that worked very well. Now, but he's sitting at home. Then his wife was required to give evidence, but he could not be present. So he had to go into another room in the house and close himself away so he could not hear the evidence that his wife was giving. And that worked, with some, interesting issues, but it all worked, and the evidence was given. Those people as witnesses gave their evidence. They were cross-examined. The coroner also asked occasional questions of them, and the whole thing worked. And this whole procedure, as I say, continued on for a total of 17 consecutive hearing days. Now, it may be that if everyone was able to attend court, it may have been a little bit less than 17 days. It may have been that there wouldn't have been the gaps of, okay, we've finished with that witness, let's get the next witness on video. But getting the next witness on video may take half an hour. So there's a break of half an hour where people are basically sitting around twiddling their thumbs, whereas if it was a courtroom situation, you'd expect witnesses to be waiting in the foyer, and they're called in, as soon as the previous witness finishes. But of course, that also has its own issues, because you could get 5 witnesses to turn up on a day, but only 3 of them get called. The other 2 have sat around all day. They've got to go home and come back the next day.
I definitely can see pros and cons of the audio video link and the technology being implemented and rolled out in courts. And one of the things that came to mind when it came to the transitioning to voice to Word document or whatever document that it is. Again, but you qualified that because whatever is being said in court gets transcribed in words because of the voice recognition capability these days. In the old days, the person that's doing all the typing, stenographer, had the capacity to say, look, there was something that I missed and could have stopped the proceeding. But that is now no longer an option. And I don't know if that's a good thing or a bad thing.
Well, it's a good thing that there be as little unnecessary interruption to proceedings. And certainly it's very off-putting for a witness who's halfway through answering a question for someone like a court stenographer to pipe up and say, oh, I'm sorry, I didn't hear that last answer. Can you say it again?
Yeah.
That's not exactly the ideal way of running a court case.
The other thing, of course, is that I'm led to understand, Paul, today and previously, whatever was converted or transcribed from what was said to words, that was online to the judge. So in the old days, it wasn't online. In the old days, it certainly took longer for the transcripts to be produced because those stenographers would have to go back to wherever their office was, in the court building or elsewhere, and actually type that up manually. Right. Okay.
These days, of course, the technology is 3 seconds behind the reality. So these days it is connected and it is running, and the transcript, basically is available within 20 minutes or half an hour of the end of the sitting period. So you get a transcript delivered to you before the end of lunchtime for the morning's proceedings.
Okay. Yeah,
and that's brilliant.
That is, yes, of course. So that was my next question, and that is the availability of what was said. That's available if you are given the permission to actually get access to the transcription. So that is amazing.
Yeah, but that getting the court transcript is different from the journalist being able to use their own personal technology to do things.
Yes.
But journalists, again, pursuant to these guidelines, journalists can get access to documents that are filed in the court in relation to the proceedings, and they can definitely get access to those transcripts to use them again for reporting purposes.
One last tickle in my the old head of mine. If there was an issue between, because technology is now more accurate than before, so where it's capturing what is really takes place, and then if there was any times when there's a difference between one that was actually in an audio format that's different from the written from the what is being transcribed. Has that ever happened? And what happens from there? What do they do when they find the difference between one audio and what's been documented?
Okay, so there's a couple of things. The first thing is that if, for argument's sake, the transcript is inaccurate because the computer has put in a different word.
Yep.
It may sound the same, but it's a different word and produces an entirely different meaning. And that happens quite often. And if it's obvious, then the court reporting service will pick it up when they're editing the transcript, and they'll change it. But if they don't pick it up because it's, let's say, a more subtle mistake, then certainly it's open to the legal representatives to realise that, and when there is a continuation of the hearing, to bring that to the judge's attention to say, well, look, Your Honour, but there's an error there. A good, easy one would be if the word was to be the word permissible, but it came out to be the word impermissible.
Right.
Or more likely to be the other way around. If someone has said in a question or in their evidence that's impermissible, there is every chance that the transcript will break that up into two words. The first word is in, impermissible, rather than one word, impermissible. And,
correct.
And of course, if that's obvious, then everyone agrees and the transcript is amended. But when it's not obvious, where not everyone agrees, then, of course, you play back the tape.
Correct. The other thing, because I was born overseas, Mr. Dellios, I just wanted to go over something. Normally, if a person is giving evidence or saying something, they might say something from their mother tongue. So what happens when another language is used in an expression or in answering? Again, that's going to bring up a different issue altogether.
Oh, yes. Look, this happens very regularly, especially in a multicultural society that we have in Australia. And again, I was involved in a case in the Supreme Court where the question was, what did someone who was making a will, the testator, say about something? And the answer was that, and the answer came in English, except when it came to quoting what this elderly lady had said about the will. And she said something in her own language, which was quoted. And then, of course, the judge who was hearing this for the first time, I mean, everybody else in the courtroom knew what the answer was going to be.
Yes.
But the judge is hearing it for the first time. So the judge, judge's eyes tweaked and, her face lit up. And the barrister who was asking the questions that produced this answer explained to the judge that the barrister had been instructed, and it appears to be common ground, that phrase means this. And for the rest of the hearing, the judge adopted that phrase every time that sort of issue was relevant in the proceeding. And even when the judge recorded her reasons for the decision, she used that phrase again, because it really was the crux of why the will was made.
Okay. We're running out of time again. I do sincerely thank you, Mr. Dellios, and I'll look forward to another session. And good night.
Good night, Jerry, and good night to your listeners as well.